SJC-13740, Jean Bennett, personal representative of the estate of Ronald Bennett versus Michael Collins, NP.
Okay, Attorney Satin.
Thank you. Good morning, and may it please the court, Adam Satin for the plaintiff appellant. This appeal arises from a medical malpractice tribunal decision concluding that the evidence as to nurse practitioner Collins was not sufficient. However, in the de novo review that this court will presumably conduct, the offer of proof timely filed by the plaintiff provided ample evidence to meet the very low threshold standard that the tribunal was bound to apply. A double board-certified expert witness in emergency medicine whose qualifications were never challenged in any way. He's board-certified in emergency medicine, internal medicine, and at the time and to the present, supervised nurse practitioners and was a clinical associate professor of nursing at Hofstra University.
I don't think we have any trouble thinking he's qualified.
He was familiar with the standard of care, and his expert report outlined a thorough recitation of the facts from his review of the medical records and a discussion of the standard of care that was expected of multiple defendants, including this nurse practitioner, Collins. He gave multiple deviations from the standard of care, and he explained the causal relationship between those deviations and the patient's demise. The dates in question were August 4th to August 5th for Mr. Collins' care, the nurse practitioner. There was an attending physician, Dr. Bosco, who is in the records as such, the attending doctor extender. The tribunal, and on a previous date I should mention, there was a similar situation when the patient had gone to the same ER and was seen by a similar mid-level provider. And
just remind me, in that parallel structure, this time they found both responsible.
That's correct.
Okay.
They found the mid-level physician assistant, who is someone who can practice somewhat independently but has certain supervisory requirements to have deviated from ample evidence that the experts report as to the deviations from the standard of care and causation were met, and they found it as to the supervising attending physician. We have the same setup on August 4th to August 5th. Mr. Collins was the nurse practitioner mid-level who saw the patient, did a number of things in the record, and there was a Dr. Bosco. And the tribunal found that the deviations as to Dr. Bosco were sufficiently set forth in the expert letter, and that the causation requirements were met because they entered a finding of sufficient evidence.
What is the finding here on the tribunal on Nurse Collins? What did they say exactly?
They literally checked a box that said the statutory conclusion that, I should say they didn't check the box that has the statutory conclusion that said there is sufficient evidence to raise a legitimate question for judicial inquiry. And they did check the box that said this is an unfortunate medical result, when they had said that there was sufficient evidence of malpractice by these other providers.
By the way, in the bigger, you say this is common because I just don't have enough sense of, but we don't have a record on. Do they just check these boxes all the time? And
what we usually get is a pro forma, pre-printed set of findings with a box for those two potentials as to each defendant.
So the bottom line here is that you think that your client was the victim of a narrowing that the judge did.
As invited.
Arbitrarily narrowing of defendants.
As invited to do so by Nurse Collins's attorneys at the hearing, essentially says, this isn't about the evidence in the case. This is about narrowing the scope of playing field, and the plaintiffs can't have it both ways. They can't have both the mid-level and say the supervisor was responsible.
But counsel, it's sort of doubly speculative to presume that that was the reason here. First of all, we don't know the reasons because we don't have a record of that, which I realize is one of your arguments. Number two, as to the July interaction, they did hold both responsible. And so that, or not hold them responsible, but tick to the box, that there was enough to go forward. So it seems just incredibly speculative to suggest that this legal argument that was improperly in front of the tribunal you're arguing was the basis.
So that is certainly correct, and we are left only to speculate. That's why I started by saying de novo review, respectfully, there's ample evidence from a qualified expert who says all the things, it's based on the evidence, he goes through the facts are in evidence. So there could be cross-examination. Heck, every trial I do, there's another expert saying the opposite of what my expert is saying, and they say on the same facts or pointing out different facts that are important, there's a dispute, and the jury decides. But that is after discovery. And the problem here, and the extreme prejudice to my client, and the problem, frankly, with the tribunals as they're being carried out, as many trials where more than is required is being expected of plaintiffs, is that we now have Nurse Collins out of the case. He couldn't pay the bond. He was indigent. The judge wouldn't reduce the bond. Case is dismissed. The discovery will now commence, and Dr. Bosco is going to be asked about his involvement. And just like his lawyer argued at the tribunal and failed, he's going to say, I didn't see the patient. You can't point to anything I did. He was seen by that gentleman, nurse practitioner Collins. And we have the so-called empty chair. And it's a prejudicial problem that will likely cost this gentleman a reasonable chance at justice.
Although you have the people from the day before, I mean, I get it if this were just, two doctors, a doctor and a nurse on one visit, but you do have the day before, or is it right? It's a
We don't. The day before, that doctor was dismissed as well for...
It's the previous visit. You have the previous visit.
It's almost a month earlier. The strongest case, to be candid, is when this gentleman shows up on the dates in question, hypotensive, elevated respiratory rate. He's got an elevated pulse. He's got the continuing joint problem that turns out to be the source of this infection, which he has an elevated white count. He has an elevated lactate level, which is acid, which in the visit with nurse practitioner Collins, who ordered the test, goes from 2.2 to 2.4, and he sends him home, deviation from the standard of care according to our expert. The next day, it's 7.7. His blood is acid, and he's in extremis. He has an altered mental state because he is in septic shock. And our expert outlined the fact that what we have here is several failures during the care and treatment by Nurse Collins and a change where it was amenable to cure, the sepsis was amenable to cure because it would have been caught early based on the parameters he outlined. And the next day, it's too late. The cascade has gone from early sepsis, which is treatable with appropriate care, to metabolic acidosis, that's that lactate level that I mentioned. He's got bands in his blood, which are immature blood cells trying to fight infection that are leaving the bone marrow early. Now, I don't expect you to know that, but the expert said it. He said he's got these changes on the next day, and it's too late. He can't recover from it. He ends up in the ICU, and he has an arrest, and he dies. And the argument at the tribunal was nowhere in the Rule 73 demand. And so our associate who presented...
Well, there's a causation argument, right?
Well, so that's interesting because keep in mind on causation, the very same causation for Dr. Bosco was found to have been sufficient evidence on the same date.
Okay, just, it helps to give us the date. Back up a second. There are how many visits in there? Because you keep referring to particular doctors, and I can't keep them straight, but go ahead.
And then again, the appeal is only as to nurse practitioner Collins, so I apologize. The the date in question for nurse practitioner Collins is essentially the August 4th, which then goes into the early morning hours of August 5th.
And August 5th, he comes back and he's,
August 5th, he gets sent home in the morning.
okay.
And about 30 hours later, he's back at the same ER in extremis with
The doctors on the last day are not held responsible, right?
at that point, it is,
Team,
they were not sued. There is not causation at that point because it's too late, according to our expert. So we didn't sue them because it was too late.
your bigger picture points, which I'm just trying to figure out, given we have a very limited record here, can we really, like you ask us to say, look, there's a major problem out there with this basically check the box solution. But I just have we don't have a record to support doing that, do we?
Sure. Well, so again,
We can't just rely on, your law firm does this a lot.
the primary, I understand your question, I'm sorry.
Yeah.
The primary argument is the offer of proof was absolutely sufficient and the tribunal erred. What we have said is Rule 73 should have teeth. We have to comply with it. If I just wrote a note saying I've had this matter reviewed and my expert tells me that there were deviations from the standard of care and it caused the gentleman's death, and I submitted that within the time frame of Rule 73, but showed up on the date of the hearing with the expert letter I have in the offer of proof on the day of the hearing, I will have not complied with Rule 73. And I would expect I would be held to the one-page offer of proof I made when I was supposed to make it. That's what happened here. They said they did Rule 73 demand, and then
But as Justice Stewart points out, this argument about standard of care is extremely weak, and we can't really say they did that. So what didn't they do that they had to do in defense? It's in violation of Rule 73.
the point as I understood it was that it's speculative to believe that's what they decided the tribunal on. The reality is the decision only as to those four people, the mid-level and the supervisor, and then the mid-level and the supervisor, is so internally and logically inconsistent, you can't tell what they did, I can't tell what they did, he can't say what they did, impossible, because it doesn't make sense.
Regardless of that, am I correct that ultimately the test, and that you're saying that the test was not satisfied, was the test in Feliciano as to what was required, and you say that your offer of proof amply satisfied that?
Absolutely, and I think Feliciano, and I know you authored the opinion in Feliciano at the appeals court, so as you might expect, I'm very complimentary of that. It lays it out, and it lays out the problem I raised about this offer of proof was made within 15 days of an answer. We haven't had an ounce of discovery. We have a preliminary report by its terms, our expert says. I haven't had the chance to hear everyone's side of the story because the law requires it then. The case shouldn't be prejudiced by a mini, if you read the transcript, this has, the way it was handled in this case, to go to your point of we don't have records of what happens in other tribunal hearings, look at what happened in this tribunal hearing. It was, I can't tell from the transcript how long it was, but it wasn't short. It took up the court's time. There are new arguments raised that my associate wasn't ready for. This all frustrates what Judge Fabricant, when she wrote to this court, asking for permission for Rule 73, this approach frustrates the exact thing she was saying this rule optimistically will fix. It'll get people to specify what the actual argument is that the offer of proof is deficient. And they just ignored it in this case, and I would suggest it happens all the time, but I understand I don't have a record of that. But the reason that this rule went in place was to prevent what she describes in detail about these cases becoming mini trials and you know, showing up for a we used to show up for tribunals, and then they'd say, there's no deviation, and we'd waited a year before we had the tribunal, discovery didn't go forward, it was a mess. So she asked for this rule. I would suggest the rule should have consequence for the defendants, just as it should have consequence for the plaintiffs if we don't make an adequate offer of proof or file one. And we do think it would be helpful if this court indicated that the court should make findings. And I know it's a de novo review. Looks like I'm over.
How do you make findings? How are they going to make findings given how early in the process this is?
Well, because it's a finding as to, it should be a finding as to the alleged deficiency in the four corners of the offer of proof, not even the expert letter. What is deficient? It would be the size of a garden variety margin endorsement on a motion saying the evidence wasn't sufficient as to they could have said, we found that the supervision was the responsibility of the doctor, not the mid-level.
I don't get what the findings would do. I mean, the wording is, it was an unfortunate accident. Maybe it's more palatable to lay people, but we know what the judge and the tribunal was really doing is saying it's sufficient or insufficient based upon the expert offer of proof, correct?
They
It's the
are.
same as saying there's a material issue of genuine fact in a summary judgment. You don't have to say why.
It would just help the court's review in a case like this.
Well, when
where
it's
this
not-
novel
unless-
question of
unless
law
it's-
is raised.
But we have de novo review versus there's no deference. We look at the same offer of proof, the same letter you submitted, and the appellate courts can decide, correct?
That's why I begin with the sufficiency of this letter by an extraordinarily qualified expert.
Chief, may I ask something? This is just for someone to check afterwards. In your table of contents in the appendix, you say that the Rule 73 demand for Nurse Collins is on page 59, but what I see on page 59 is actually your offer of proof with respect to Collins. So I just want to make sure, and it's not to check right now, it's to check later. If Collins's demand is not in the record, can someone just file it, please? Or let us know, maybe in a subsequent letter, what page it's actually on?
Yes, it's 221, but I'll send out a letter correcting
Okay,
that.
thank you.
Thank you.
Thank you. Attorney Waldron.
Good morning, and may it please the court. John Waldron on behalf of the defendant appellee, Mr. Collins. It's the position of Mr. Collins that there was a sufficient basis for the tribunal to find in favor of him, and that's on the issue of causation. The issue was raised in the tribunal demand. It's an issue that comes up at essentially every medical malpractice tribunal, as it's an essential component.
Confused though, how can they find the supervising doctor has to stay in, but he goes out, given he's the only one who saw him on that day? I'm confused by that.
I am too, and I don't have an explanation for it, respectively.
That's a problem, right?
Well, they found in favor of Dr. Willis, who saw the patient the day prior, and found in favor of Mr. Collins, who saw the patient the following day. So
The day prior, again, there's a parallel, right? And what do they do on the parallel structure the day before? They knock them both out? I can't remember what they do. There's one day the supervising is kept in and the other person is let out. The other day, what happens the previous day? Or a couple of days earlier or something like that?
Sure. So there were two mid-level providers. One was a physician assistant, one was a nurse practitioner. Physician assistant Hickson, nurse practitioner Collins.
They keep Hickson in, right?
Yes, Mr. Hickson saw the patient about 4 weeks prior to Mr. Collins. Both Mr. Hickson and his supervising physician were kept in the case. They found that the proof was sufficient.
So doesn't that undermine the theory that they're going, the duty of care theory, that they're somehow letting out PAs and nurses and keeping doctors in? It just doesn't seem to make, I just can't square all of this. It doesn't make any sense.
So I think the 4-week time period between those two provisions of care explains why they could find causation for Mr. Collins and not for Mr. Hickson.
Can you tell me why, I'm looking at the expert letter, and it has a paragraph on causation. Why is it deficient? As a direct result of NP Collins'.
Sure, so under the I'm sorry.
No, I was just reading the first to help you find it. It's on RA 164 or 58.
Well, it states that it would have been diagnosed and treated earlier in time when it was amenable to cure. It's inconsistent with the actual treatment course. When the patient presented to the hospital or returned to the hospital after being discharged by Mr. Collins, the amount of time that it took to actually diagnose the issue is significant, because the contention is that
But isn't that a factual issue? And a difference of opinion?
It could be, yes. But it's actually, but the opinion, I think, is based on the ability for this condition to be diagnosed by certain mechanisms if he was kept in the hospital.
Right, and that relies upon your expert's opinion, correct?
Yes, and what actually took place. So the opinion has to be rooted in the evidence.
But it is rooted in the evidence, because you said if the patient were kept in the hospital, right?
Yes,
And Collins discharged him.
correct. By the time it was diagnosed, his condition had advanced so far that it was not
But
treatable.
then it makes no sense to let to keep the supervising doctor in, because the supervising doctor is the same day and doesn't even see the person.
Doesn't see the person, and Collins orders all the blood work, gets all the results back, sees all the elevations. What type of new math is this?
I didn't know, my firm doesn't represent the supervising physician.
Yeah, no, I get it.
So I
No, but
can't argue on
I
behalf,
think,
but
I think
perhaps
you
we
have
should.
to answer the question of why the evidence presented by the plaintiff doesn't raise a legitimate question of liability with respect to your client. I understand that your client may have all sorts of defenses after discovery. Maybe it was to the time between August 5th when he was discharged and August 7th when he's returned and he's totally septic. Maybe, there is some defense that you can marshal on behalf of your client. But why doesn't what was presented here as the offer of proof with this expert who you don't question their qualifications on, not enough to raise a legitimate question of Nurse Practitioner Collins's liability?
I think we have to look at the issue of causation.
But the expert says it was caused
That's
by this failure.
That's the as a direct result paragraph.
In the argument at the tribunal by counsel for Mr. Willis, or Dr. Willis, who saw the patient just prior to Mr. Collins and who argued just prior to counsel from my office, contended that it was inconsistent with what's in the records, the actual treatment course that took place, that the imaging didn't reveal this condition, that the workup that would have been done at the hospital wouldn't have diagnosed this condition until it was.
Yeah, if you were making that argument and it were actually a motion for a directed verdict, you would lose, right? Because the judge isn't supposed to resolve those conflicts. So it seems a little weird to allow the tribunal to resolve those conflicts and not let the case go forward. Wouldn't you agree?
I agree that the threshold is low.
Right, and so it seems that the tribunal is, at least in this case, imposing a threshold that is inconsistent with their mission. I'm not saying Nurse Practitioner Collins is liable or not, but this raises a legitimate question.
Respectfully, Your Honor, I would disagree.
I have sorry,
No, go ahead.
another question for you. Would you agree that the argument made to the tribunal that it would make sense to narrow the case is not really a legitimate basis upon which the tribunal can act?
Yes, and I don't think the tribunal accepted that argument because they kept in one mid-level provider and the supervising physician, but let one out. So it seems to be that that argument was rejected, and to the extent that there's an
It
argument.
should it have been made?
I don't know that should not have been made. I can't comment on that. I personally did not make the argument.
Can I ask you another fact question? I know there are two cases, I may be confusing them a little bit, but did he saw a doctor the day before for his arm problem? I can't remember. So I'm just trying to somehow make sense of the fact that this nurse is kicked out and another doctor is kept in, but did he see a doctor the day before he saw Mr. Collins? Not at the hospital, but separately, he saw his arm specialist or something?
Yes, it was an orthopedic physician.
So he saw an orthopedic physician the day before he saw Mr. Collins, and the orthopedic surgeon didn't do anything either, didn't notice anything either.
Correct.
Is that person still in the case, or is?
No, they're the other defendant who was let out of the case.
So they were let out of the case too, okay.
I'm sorry, who was that? That was
Dr. Willis, he was an
Willis,
orthopedic
it was
physician who
Willis.
saw the patient the day prior to when the patient saw Mr. Collins.
So he was let out of the case.
Yes.
Who was Richmond?
Richmond, I believe, is plaintiff's expert.
Okay, thank you.
So Willis, who's a doctor, sees him the day before Collins sees him, doesn't detect any of these problems, and he's let out of the case. Then your client, okay, I don't know, it's a mess.
Just on the issue of the argument being waived, I understand the allegation that the argument was improper, but Rule 73 does call for, or does contemplate certain circumstances where there is waiver, such as waiver of the right to a tribunal if a demand's not filed timely, or waiver of a tribunal by a plaintiff if an offer of proof isn't filed timely. There's no mention about necessarily waiver of certain defenses if they're not specified to a certain degree or adequately in the demand for a tribunal. And Justice Fabricant's letter really got to the purpose of trying to get these tribunals more timely, and thought to include these demand components because they thought they might eliminate some of the demands for tribunals, having to spell out some of the deficiencies in there. There's no mention about putting the opposing party on adequate notice, although that may be part of it, or any consequences to failing to adequately do so. And even if this argument wasn't gleaned from the tribunal demand, it was addressed by the counsel at the tribunal, by plaintiff's counsel. We had an opportunity to rebut all the arguments and address it at the end and refute this contention that somehow the mid-level and the provider could not be both held liable at the same time. So the record really doesn't show that that impacted the decision of the tribunal. And ultimately, it's the four corners of the offer of proof that serve as the basis for the tribunal's decision. Oral arguments or advocacy by attorneys. These offer proofs are submitted to the tribunal panel. They review them. We present and argue on behalf of our clients and answer questions, but ultimately what the evidence is within the four corners of the offer of proof.
Isn't that the problem?
According to the plaintiff, yes.
You must have done a very good job down below.
If no further questions, I will rest.
Okay.